Today we are going to discuss the module on dams and the environment. Dams are one of the key infrastructure that has been deemed to help in the modernization of the country. The environmental consequences, the significant negative environmental consequences have been debated for a long time, but the legal framework that surrounds those environmental consequences has been relatively weak or not sufficiently implemented. Hence, there are many issues that need to be debated. Now, what is the context for what we're talking about? Dams were an engine of development in OECD countries for a number of decades. Progressively, after the end of the Second World War, that desire for building dams slowly declined up to the point where by the 1970s, when the environmental movement had started in full strength and when environmental law has started developing, at least at the national level, there was one famous case, as in that has become famous in the meantime in the United States, where a dam that had already been built was stopped from being commissioned because it was going to affect, namely lead to the extinction of an endemic species, so known as the snail darter, that was endemic to that area only. So that's kind of the end of dams in OECD countries in terms of the big push for building big dams and understanding dams mostly as an engine of progress rather than as an engine of progress and having significant environmental as well as in certain cases social consequences. Now, in the south, a converse trajectory was followed in the sense that it's from the 15th and 60s onwards that dams started being seen as an engine of development and modernization. And that's nowhere best visualized than in the statement of the first Prime Minister, Pandit Nehru, who said at a relatively early phase in the post-independent era that dams should be seen as the new temples of India. As we know, that's a statement that was subsequently revised, but the fact is that we are still talking about it today, and the fact is that that was a very significant moment in terms of the way in which dams were looked at in the process of nation building. What were dams first advertised or planned for in the post-independence period? First of all, and overwhelmingly for food security. So in other words, it's the irrigation rationale that justified the building of the various dams that started being planned after independence. A secondary aim was hydropower, so that from the start there was often a hydropower component, but that was generally subsidiary to the food security rationale, in other words, the irrigation rationale. Over time, that is at least since the 1980s onwards, and progressively much more so, drinking water has also become a rationale in itself for building dams, and we now have dams that are built primarily to satisfy drinking water needs. Now, one of the issues is that dams have been debated for a long time, but the debates around dams have focused largely on costs and benefits. In other words, in a largely economic analysis of what a dam brings to the country, what are the kind of benefits that can be expected compared to the cost of building the infrastructure and operating the infrastructure. What has been discussed much less are the legal dimension of dam building, and in particular of the negative consequences arising from the building of large dams. Now, what is a law and policy framework within which we can look at the environmental dimensions of dam? There are instruments that apply specifically to dams, but there are few of them, and there are some instruments that include dams in their scope, in a scope that will include other issues or other forms of infrastructure, for instance. In an environmental context, the main point of contact between dams and environmental law has been, for a long time, environmental impact assessment. Environmental impact assessment is not a dam-specific environmental law instrument, but in fact, it is very significant that the EIA was kickstarted in a dam context in the late 1970s, and the first legal instrument that was put out by the Ministry of Environment and Forest in the 1980s was, as in concerning environmental impact assessment, was the guidelines for environmental impact assessment of river valley projects. It's only in the 1990s that environmental impact assessment was made a statutory requirement in the context of the EIA notification of 1994. This does not apply only to dams, but it was a very important step because it did include dams as part of its scope, and the clearance requirements that were included in the notification were a major step forward in terms of recognizing that dams needed to be assessed not only from a cost-benefit perspective, but also from an environmental perspective per se, without looking at the other issues together. Now, the EIA notification of 1994 may have been insufficient in its own right. It was largely seen in the sense as the first step in the building of a regulatory framework, but in historical hindsight, we can now tell that it appears as the high point of regulation in this field, because the general trend after 1994 has been rather towards a weakening of the framework that was put in place then, rather than strengthening it. So this is as far as the environmental impact assessment and dams is concerned. Another element which needs to be taken into account in terms of legal frameworks is the Forest Conservation Act. The reason for this is because dams also affect sometimes forested areas, in which case the stipulations concerning the diversion of forest to non-forest purposes need to be followed. There are various other laws that are also relevant. One which is very directly relevant, even though it does not really focus on dam per se, is the Interstate River Water Disputes Act of 1956. It's, as the name implied, about water disputes, but the fact is that in practice, the disputes that have arisen have often been related to dams and the potential for dams to allocate or reallocate water away from the river or from an interstate river. Another stream of legislation that's relevant are all the irrigation acts we have in the various states of the country. Irrigation acts are not dam specific at all, but all the irrigation acts we have until now are driven by the needs of surface irrigation through canal systems fed by dams, and in that context are very much directly related to dams, even though they don't talk the dam language directly. Dams are also relevant in instruments beyond the strict legislative framework. So for one of the examples we can give is the hydropower policy of 2008, whose objective is to induce private sector investment in hydropower and harness the hydroelectric potential of the country. So hydropower is necessarily linked to the building of dams. The hydropower policy itself is not concerned with dam, but one of the outputs, the potential outputs of dams. That also confirms that over time, hydropower did become a more important rationale for dam building compared to the irrigation rationale. More recently, following various controversies and concerns, in 2010, a dam safety bill was drafted. That's a key proposed piece of legislation in terms of ensuring that the infrastructure which is in place is safe to be used and that there is a regulatory framework for the same. That bill lapsed in the last parliament, but there are new measures or similar measures being considered by the present government. This is definitely something that will come back and that will most probably be considered in one form or another at some point. Finally, there are also acts which are essentially linked to dams, even though they have nothing to do with dams per se. One of them is the regulatory framework concerning land acquisition. Land acquisition is a precondition for dam building and dam projects. Hence, the regulatory framework for land acquisition is related to dams, even though it does not necessarily appear that it is made with a view to either foster or stop dam project. In that sense, the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act of 2013 is also dam-related legislation. And I'm mentioning it here because land is so important to dam project, even though the land acquisition legislation is not particularly mindful of environmental consideration. Hence, for our purposes, likely less directly relevant. Now, to go beyond these general statements about the legal framework, which remains rather vague and not very developed, one needs to go into specific case studies. So there are thousands of dams that have been built, so there are thousands of potential case studies. One of them, which is a particularly good case study, is the Sardar Sarovar project on the Narmada River. And the reason why it's a particularly good case study here is because there's been an engagement with the legal framework, in particular through the courts, but not only, for several decades, that has contributed to the development and our understanding of what the legal framework is concerning dams. The Sardar Sarovar project is one of 30 big dams planned on the Narmada River, and part of a much bigger scheme of building thousands of dams on the river. It's a multi-purpose dam that was conceived, first of all, to provide irrigation benefits to the state of Gujarat, but progressively, since it's a project that's been in the process of being built since the 1960s, an additional basic rationale of providing drinking water was also added. Beyond that, there is a hydropower component, which is supposed to be the benefits that the two states of Madhya Pradesh and Maharashtra, who only get submergence out of the dam, that's a benefit they're supposed to get in return for providing some land to be submerged by the dam. The planned benefits of the dams include a distribution network system of 75,000 kilometers, provision of drinking water to 9,633 villages and 131 towns. And in addition, in terms of hydropower, peak production of 1,450 megawatt of electricity. The other side of the project is the impact that it is likely to have once it is fully constructed. That includes displacement, so that comes before the environmental impact, because in human terms it's more important. Displacement of which estimates are between 40,827 families. That's the estimate that the Supreme Court gave in 2000. In other words, around 2 lakh people, with other estimates going up to 5 lakh people being displaced. In any case, a very large number. So displacement is a key issue, but displacement is not specifically an environmental issue, even though it has environmental components, so that's not the focus of this unit. One of the important aspects in one of the important impact of the Sada Sarovar project is its environmental dimension. Hence, in terms of legal issues, one of the important aspects of the project is its environmental clearance. Since, again, as I mentioned earlier, environmental impact assessment has been from the 1917 onwards the main point of contact between environmental concerns and dam building. There was a first set of environmental conditions set in the 1980s, at the time at which the actual construction of the dam started. These environmental conditions were found in an independent study of the dam in 1992 not to be met, which led to the withdrawal of the World Bank from the financing of the project. Later on, environmental clearance became itself an object of much debate in legal terms and was the second main issue that was debated in the main Supreme Court judgment of 2000 on the Sada Sarovar project, but besides displacement. In this case, what was discussed were not the conditions introduced in the mid-1980s, but an endorsement by the Prime Minister in 1987 to determine whether that constituted clearance or not. What is interesting is that this clearance was undertaken before the formal adoption of the environmental impact assessment notification in 1994. So there was a discussion around what this clearance meant in a context where the regulatory framework was not yet fully developed. Beyond this, the 2000 judgment did not go as far as providing a framework within which the dam should be assessed under the EIA notification of 1994. That's a key aspect in a context where the notification itself provided that any project that had not been completed within 5 years of the clearance having been given would require new clearance. Now, what is it that we learned from the 2000 judgment in terms of the development of environmental regulation related to dams? First, the Supreme Court asserted at paragraph 278 of its judgment that the dam was ecology friendly because its contribution to climate change was negligible. So now that's important because until now, the debates we seem to have been discussing in both legal and policy terms were about the negative environmental consequences of dams. Here we move to a new era, which started more or less around the turn of the century in many parts of the world, where dams are now seen as having a positive environmental image because the form of energy they provide, namely hydro power, is seen as being positive from a climate change perspective because there is no emission of CO2 gases linked to the dam itself, linked to the production of hydro power. So in a sense, we move from looking at environmental aspects of dam with a suspicious eye somewhere to a point where we say that actually the dam is good for the environment, hence there is a balance of pros and cons also within the environmental debates surrounding dams. Second lesson from the judgment, from the 2000 judgment, is that the court tells us that the dam is linked with the realization of the fundamental right to water. So it's important because the dams is then seen as an instrument that contributes to the realization of fundamental rights. But what is needs further discussion is that it talks only about the fundamental right to water of people benefiting from the dam. It does not link that with either fundamental right to environment or other fundamental rights that may be affected by the dams. So it's important because the judgment realizes that there is a link between dams and fundamental rights, but there is a limited framework within which that is done. Now, a third lesson that we learn from the judgment is that the court tells us that, that's paragraph 265, that large-scale river valley projects per se all over the country have made India more than self-sufficient in food. That again is important from an environmental point of view because the dam is justified as providing a climate-friendly source of energy and, in a sense, contributing to food security. This seems to provide the basis for not necessarily balancing that, again, the impacts on the river, both upstream and downstream, the impact on the catchment area, and the impact in the command area. So there are new environmental dimensions that are added within a context of food security, which remains the primary rationale for dams, but the broader environmental context, which is by now well understood, is not fully taken into account. What is it that we learn from the existing legal framework and the case studies we have where the framework is applied? We understand from the early phases of the development of the legal framework, the environment-related legal frameworks, that dams may cause significant environmental harm, and that needs to be taken into account in the development of dam project. Yet, despite this early recognition, what we see over the past few decades is that the legal framework has not been particularly strengthened. In fact, again, when we look at environmental impact assessment, there seems to have been some sort of a peak in the mid-1990s, and we have not managed to go beyond what was achieved in the 1990s. Now, does that mean that we don't need a stronger environmental law framework today? Maybe because we have moved away from dams being built in the process of modernization and development. Well, that does not seem to be the case because there is, for instance, a proposed interlinking of river scheme, which would see the building of many more dams to provide the links between the rivers. And in that context, a strong environmental regulatory framework does seem to be needed. What is it that we have overall? Well, we have the law, the existing law provides a number of entry points to address the environmental impacts of dams, but much more needs to be done in terms of strengthening the legal framework and in terms of applying it in a broad and comprehensive manner that takes into account all the various elements that need to be taken into account. Thank you very much.